Danny Kruger.
Thank you very much indeed. Mr Deputy Speaker, I rise to support the bill and the amendments that the Government has tabled with the Honourable Lady's support. I recognise that despite the Equality Act, we have a significant problem in our culture and in our society, and too many people are the victim of absolutely unacceptable and outrageous harassment and intimidation and abuse in their workplace, particularly sexual harassment. And I recognise the powerful points that the Honourable Lady has just made. And of course the problem arises largely because these occasions of harassment frequently go unreported because they go ignored by employers. So we do have a significant problem in the culture, and then so the question arises for us: what can the law do about it? And I want to speak in support of the amendments that the Government has tabled, but also to raise some concerns about the drift of legislation that we've embarked on. I very much recognise the responsibility that employers have to set the atmosphere, to create the culture.
Hearing, I indicated very clearly the difference between report stage and third reading. The Honourable Gentleman, if he wishes to speak now, must speak to the amendments. There will be an opportunity to go broader on third reading. Danny.
Thank you, Mr Deputy Speaker. I am speaking to the amendment, so I'll be more explicit about that and jump straight into it. I think the amendment to Clause 1, Clause 1 itself is very helpful, and the amendment supports it. And I recognise particularly how Clause 1, as drafted, would have protected Kathleen Stock, the professor at the University of Sussex, who was the victim of harassment and intimidation at her university, and the university didn't step in to support her. The problem is it would have also prevented Kathleen Stock from speaking at other universities, because those universities would have insisted that their employees were the victim of harassment or abuse by her presence. So we have a real problem with universities, particularly gold-plating the Equality Act and other legislation, and the excessive invocation of the Equality Act, which shouldn't be happening. The problem I have with the laws as drafted before the amendment is that it would not have only have justified, but could have necessitated the sort of censorship that we need to be concerned about. So I also recognise that the law as drafted and now as amended has a particular challenge to public-facing employers whose work involves the public, because the bill does not simply seek to prevent intimidation on the part of fellow employees, but on the part of members of the public as well. And I'm concerned about the concept of reasonable steps that employers are expected to take. I mean, and I'm going to make a few absurd suggestions, and I'd be interested in the Minister's response on whether these scenarios under the amendment that we're supporting will indeed prevent this. Will pubs be expected to put up signs saying no banter allowed in order to make reasonable steps to prevent harassment? Because, of course, the three strikes rule, which was in the original Act, which was not implemented in 2013, ensured that what was prohibited was a course of harassment, a course of conduct which was harassing. Now employers are expected to prevent, head off at the pass, any possibility of a harassment, because they are liable at the first instance of harassment. So will pubs be required to proactively prevent anything that might be constituted as harassment? Another example, I mean, the fact is that a censorious spirit has entered the soul of organisations which hold power and responsibility in our country, and we've seen, I think, a somewhat absurd instance of that this week with the Welsh Rugby Stadium, which is banning the singing of the song Delilah, and the local police chief tweeting in support of this, as if it's his job to determine what fans sing. I just put this absurd suggestion to the Minister: what if a crowd at a football match were to chant or to shout "You're blind" at the ref, and a partially sighted steward or hot dog seller or some other employee of the stadium were to hear that? Surely they would be entitled to at least make a claim under this Act. And if not, I'd be very grateful for that confirmation, because I do very much applaud and recognise the amendment which has been introduced. I want to finish by confirming my support for that. There's a whole list of criteria which is now required for the Act to be enforceable. I'm not totally clear, and I think I heard the Honourable Member, the Minister, list them all out. I'm happy to give way to the Honourable Lady.
Maybe can I advise him that the Equalities and Human Rights Commission is going to give guidance to employers to exactly help them to get through these issues. So we are waiting for the guidance, which will be published shortly, but can I advise him that he looks up that guidance?
I'm very grateful to the member for that advice, and absolutely, and we look forward to that guidance, and I have great faith in that commission under its present chair to make sensible guidance. So I would just be grateful for clarity that the list of criteria and eligibility for the law to be triggered are individual criteria. So if any of these criteria are not met, then the law doesn't apply, or is it that every single one of them must be met in order for an employer to be exempt from the operations of the Act? I fear that if they're all required to be met, that's a very, very high bar which employers are going to have to get over, and I'd rather it was just any of them being met. And I want to end, Mr Deputy Speaker, just by expressing my concern about the spirit of law which we increasingly have, which is simply declaratory. What we do is we decide that something is bad in our society, and we pass a law saying that it's bad and that it should not happen, and we expect that to work. What we need to consider in drafting and passing legislation is the actual effect of the law on the people who will be responsible for enforcing it, given the culture and given the effect of the culture on the law. The law is a teacher, and we have to be aware of the attitudes and the spirits and the fears and the politics, including the increasingly transgressive politics of people with power in public life in our country, about how they will use the laws that we're passing, and in future times what will be done with laws like this. So I'd be grateful for reassurance on these points from the Minister. Thank you.
Does the Minister wish to respond? Minister.
Thank you, Mr Deputy Speaker. I thank the Honourable Member for Devizes for raising the points that he does. The amendments to the bill do make it the case that any harassment has to be directed to the employee. It can't be simply third-party conversations which are overheard. But I would take, and to his specific point, all of the conditions have to be met in the amendments. So all conditions need to be met in order for the amendment to be triggered. So I recognise he says that's a high bar, but that is the case. But I would just gently say, in a couple of the examples that he gave in terms of will banter be banned? Well, actually, if that is directed to the employee, that can be sexual harassment, and one person's banter is another person's harassment. So I do think we need to be mindful of that. And in terms of the other example of a footballer, where the crowd are singing a song or directing a chant, that can be targeted harassment. And we've had multiple examples of footballers either targeted because of their race or colour, and that isn't acceptable, and football clubs do take action now. As the Honourable Member for Bath said, guidance will be issued for this. We understand it's going to be difficult for employers, and they need clarity going forward. That's why we've put these amendments down today, so that third-party conversations that are not directed at an employee and all those conditions are met in the amendments will be exempt. But direct harassment of an employee, whether that's banter or whether that's a song at a football match, is still harassment, and that's why we do need this bill going forward.
The question is that Amendment 1 be made. As many of the opinions say aye, contrary no, the ayes have it.